Hello guys and welcome to the Law Putra's YouTube channel. My name is Jagannath Kulkarni and today's our topic of discussion is summons or also called as subpoena. First of all, let us see what is the definition of summons. And interestingly, it has not been explicitly defined under any statute, may it be civil procedure or may it be criminal procedure. So, the judiciary or the courts, they have to rely upon the law lexicon. Let us see what is the first law lexicon by P. Ramnath Iyer says. It says summons is a process issued from the office of a court of justice requiring the persons to whom it is addressed to attend the court for the purpose therein stated. Another law lexicon by Barton says summons is the means by which one party brings the other party before a judge to settle the matters of details in the procedure of a suit. Now, we need to see why the summons is required. What is the necessity of summons? And it is for the trial to be fair. It is the rule of law and it is the principles of natural justice why summons is required. So, we all know that odi alteram partem, that is the Latin phrase, which means in simple English that no one should be condemned unheard. This is one of the two basic principles of natural justice. And it is an individual's right to a fair trial, which has been incorporated in ethos of our constitution as well as the legal machinery. Now, summons are required to ensure justice is being served. That is, all the parties involved, they must be given a chance to be heard. Then it is required to inform the person to whom it is issued about his involvement in legal proceedings. It is also required to give him a chance to set the record straight with the court, give his version of facts and defend himself or herself. So this is the necessity of summons. Now let us see the essential ingredients. As we have seen, it is not defined in any statute, but the essential ingredients have been given or we can find them in both Code of Civil Procedure 1908 as well as Code of Criminal Procedure 1973. If we go into the details, we can find section 27 to section 29 and section 31 of Code of Civil Procedure as well as Order 5 and Order 16. And if we look at the criminal procedure, it is from section 61 to section 69 and few other sections also. Now let us see these essential ingredients. Let us start with the criminal procedure from section 61 to section 69. 61 talks about the forms of summons, 62 talks about summons, house served, 63 talks about service of summons on corporate bodies and societies. 64 talks about service when person summoned cannot be found. 65 talks about procedure when service cannot be effected as before provided. 66 talks about service on government servants. 67 talks about service of summons outside local limits. 68 talks about proof of service in such cases and when serving officer cannot be present. Then section 69 is service of summons on witness by post. So these are the basic sections from criminal procedure. There are also few other sections like for example section 87 which talks about issue of warrant in lieu of or in addition to summons. Then section 90 talks about the provisions generally applicable to summonses and warrants of arrest. Then section 91 talks about the summons to produce document or other thing instead of calling witnesses to produce something or to give evidence. 113 talks about summons or warrant in case of person not so present. Then section 114 talks about copy of order to accompany summons or warrant. Section 175 talks about the power to summon persons. Section 187 talks about power to issue summons or warrant for persons committed beyond local jurisdiction. Then another some sections, that is section 206, talks about special summons in case of petty offence. Section 259 talks about power of court to convert summons cases into warrant cases. 274 talks about record in summons case and inquiries. 311 talks about power to summon material witness or examine person present in the court. Then section 350 talks about the summary procedure for punishment for non-attendance by a witness which is in obedience to summons. Now let us see the civil procedure. What are the provisions available? And as we have seen, civil procedure contains sections as well as orders and then rules. Now section 27 talks about the summons to defendants, which is our today's topic of discussion. Then 28 talks about service of summons, where defendant resides in another state, that is out of the court's jurisdiction. Then 29 talks about service of foreign summonses. And finally, section 31 talks about summons to witness. Now if we see order 5, order 5 is about issue and service of summons, and order 16 is about summoning and attendance of witnesses. Now let us see in detail. Code of Civil Procedure, first we will discuss about section 16, which talks about summoning and attendance of witnesses. Rule 1, now we know under order there will be various rules and under rule there will be sub-rules. So rule 1 of order 16 says list of witnesses and summons to witnesses. Then rule 1a, which is further added, subsequently added, talks about production of witnesses without summons. Rule 2 talks about expenses of witness to be paid into court on applying for summons. Rule 3 talks about tender of expenses to witness. Then Rule 4 talks about procedure where insufficient sum paid in. Then Rule 5 says about time, place and purpose of attendance to be specified in summons. It is required to be given in the summons. Then Rule 6 is to summons to produce document. Now there will be Rule 7, which talks about power to require persons present in court to give evidence or produce document. Then Rule 7a, which is again subsequently added, is about summons given to party for service. Then Rule 8 is summons house served. Then Rule 9, time for serving summons, and Rule 10, procedure whose witness fails to comply with summons. Rule 11 is about if witness appears, attachment may be withdrawn. Then Rule 12 is about procedure if witness fails to appear. Then Rule 13 of Order 16 is about the mode of attachment. 14 is about court may of its own accord, suo motu, summon as witnesses strangers to suit who are not the parties to suit. Then Rule 15 is about duty of person summoned to give evidence or to produce document. It is their duty. Rule 16 is when they may depart. Rule 17 is about application of Rule 10 to Rule 13, which I have seen earlier. Then Rule 18 is about procedure where witness apprehended not give evidence or produce document. Rule 19 says about no witness to be ordered to attend in person unless resident within certain limits. Then Rule 20 is consequence of refusal of party to give evidence when called on by court. What happens when he refuses? Then Rule 21 is rules as to witnesses to apply to parties summoned. Now let us see what Order 5 talks about, which is about the issue and service of summons. Again, there will be two parts. First is the issue of summons, another is service of summons. Now Order 5 Rule 1 talks about summons. Rule 2 says about copy or statement annexed to summons. Rule 3 says about court may order defendant or plaintiff to appear in person. Rule 4 says no party to be ordered to appear in person unless resident within certain limits. Rule 5 talks about summons to be either to settle issues or for final disposal. Rule 8 talks about an issue of summons for final disposal to be directed to produce his witness. Then Rule 9 says about delivery or transmission of summons for service. Now from Rule 9 onwards it is about the service of summons. Rule 9a says about summons given to plaintiff for service. Rule 10 mode of service. Rule 11 service on several defendants. If there are more than one defendants, how it will be served. Then service to be on defendant, on person when practicable, or on his agent. Then Rule 13 is about service on agent by whom defendant carries on business. Then Rule 14 is about service on agent in charge in suits for immovable property. Rule 15 is about where service may be on an adult member of the defendant's family if the defendant is not available. Then Rule 16 is person served to sign acknowledgement. Procedure when defendant refuses to accept service or cannot be found, we can find it in Rule 17. Then Rule 18 is about endorsement of time and manner of service. Rule 19 is about examination of serving officer. Rule 20 is about substituted service. Rule 20A talks about service of summons by post. Then Rule 21 talks about service of summons where defendant resides within jurisdiction of another court. Then service within presidency towns of summons issued by courts outside jurisdiction. Then Rule 23 talks about duty of court to which summons is sent. Rule 24 talks about service on defendant in prison. Then Rule 25 talks about service where defendant resides outside India and has no agent here in country. Then Rule 26 about service in foreign territory through political agent or court. 26A talks about summonses to be sent to officer to foreign countries. 27 talks about service on civil public or on servant of railway officer or on servant of railway company or local authority. Then Rule 28 is about service on soldiers, sailors or airmen. Rule 29 is about duty of person to whom summons is delivered sent for service. Then Rule 30 is about substitution of letter for summons. Then Rule 10, which is our today's topic of discussion, we will elaborate it, is mode of service. Now Rule 10 says service of the summons shall be made by delivering or tendering a copy thereof signed by the judge or such officer as he appoints in this behalf and sealed with the seal of the court. So this is how the service of summons will be done. But we need to see the methods, different methods, and there are 5 methods. Number 1 is personal service or direct service. Number 2 is service by court. Number 3 is service by plaintiff. Fourth method is substituted service, which needs to be used only as a last resort. And finally, fifth is service by post. The first service, which is personal service or direct service, here summons must be served on defendant in person or by an authorized representative wherever possible. Now, if defendant is absent from his residence at time of service of summons, then it may be served on any adult member or female member of defendant's family. But remember, servant of the defendant cannot be said to be a family member. Then, where there are 2 or more defendants, summons should be served on each defendant. Service of summons should be made by delivering a copy of summons. After that, serving officer must make an endorsement on the summons regarding delivery of summons. Let us see the second method, which is service by court. When a defendant is residing within court's jurisdiction and where defendant is residing outside the court's jurisdiction, how summons will be served. In first case, it shall be served through court officer or any approved courier service. But in second case, it will be served through an officer of the court within whose jurisdiction such defendant resides, and it shall be the definitely another court. Now let us see the third method where service will be by plaintiff. Remember, this will be in addition to service of summons by court. Court may allow the plaintiff to serve the summons, so it will be double delivery. Then fourth is the substituted service. Remember, this should be used only as a last resort. If defendant or his agent refuses to sign acknowledgement, or if serving officer is unable to locate defendant after due diligence and there appears to be no chance of finding him, then in that case service of summons can be done by fixing a copy of summons on outer door or some conspicuous, which means noticeable, part of house in which defendant resides or carries on business or personally works for gain. That is the current position, present position. Where court is satisfied that defendant is avoiding service of summons or summons cannot be served on defendant in an ordinary way, service may be achieved either by affixing a copy of summons in conspicuous place in courthouse and also where defendant last resided, carried on business, and where he personally worked for gain or in such manner as court may think fit. Remember, this is the past tense. Now, let us see what the court says about this. Court says one must remember that this service, that is substituted service, is not a regular mode of service. Hence, it should not be normally be allowed and it should only be used as last resort. And the case is Basan Singh versus Roman Catholic Mission, year 2002. Now let us talk about the last service, that is the last method, which is service by post. When court receives an acknowledgement purporting to be signed by defendant or his agent, or when defendant or his agent refuses to accept delivery of summons when it is tendered to him, the court issuing the summons shall declare that the summons had been properly served. So this is the fifth and last method of service by post of summons. Now, Code of Civil Procedure also has section 27 which talks about summon to defendants. Then section 28 talks about service of summons where defendant resides in another state. Section 1, then subsection 2, and then subsection 3 with clause A, clause B. Right? It is about the translation of summons in another language when the language of the court is different. Then the Hindi is the priority and it can be the bilingual where Hindi is not the court's language. Now this is about the section 29 which is service of foreign summonses. How they can be served. Remember, summons to witness is the same 27, 28, 29. These three sections provisions apply to for witnesses as well. Remember, summons Indian courts spent 273 days serving a summon, and it is the need of the hour that technology can speed this up. Who says this? This is the Jaldi. Jaldi is justice, access and lowering delays in India. And this report is by Vidhi Center for Legal Policy. This report highlighted certain roadblocks in searching of summons and for expediting and streamlining the process through ICT, that is integration and communication technology integration, information and communication technology. What we can do, let us see what is the cause for delay. In the event, and judicial recognition through electronic mail or other messaging apps. In 2010, Supreme Court had allowed an electronic mail notification to be sent along with the ordinary mode of operation. So email are acceptable in the courts as well. And this is the case Central Electricity Regulatory Commission versus National Hydroelectric Power Corporation Limited. Court also said that this practice should be observed in commercial disputes and in cases where immediate interim relief is requested by Supreme Court. In addition, high courts such as Bombay and Delhi, they have also begun to recognize value of services such as WhatsApp for service of court notice. So through WhatsApp also, which is our regularly we are using, summons can be served. However, remember, although these approaches suggest a transition towards electronic methods of serving a summons, in such situations, it is difficult to obtain sufficient proof of service delivery. Different methods for information collection. This is one of the area where we need to collect the information, and lack of sufficient details on group being served. We need to collaborate with other government departments to access their databases, and each High Court in collaboration with other government departments can create an application that allows access to their independent contact information databases. Request for information from public. This also can be done by subscription model. High courts can allow these individuals to subscribe to their website to receive e-summons, electronic summons issued against their name. And register of panel advocates, state governments and central government agencies, they have the panel advocates at each high court. In cooperation with central agency, registry of high court can maintain a regularly updated register of information for such persons. So this is all about the summons and subpoena. Remember, it is a legal document issued by a court seeking before it the presence of any entity, maybe natural entity or corporate entity involved in a legal proceeding. Thank you. Thank you very much.